Good morning and welcome to an oral argument session in the 5th District Court of Appeal. Let me begin by introducing the panel. As you've heard, I'm Judge Palmer. To my right is Judge Sawaya. To my left, we're happy to have Associate Judge LaRue from the 7th Circuit joining us to help out this week. We have both criminal and civil cases on the docket today. Criminal cases 15 minutes each side, civil cases 20 minutes each side. The appellant can reserve as much of their time for rebuttal as they like. We will have one panel change before the last case on the docket today. The first case on the docket is McMillen v. State.
Morning, Your Honor. Flynn Whited for Delbert McClinton. I'd like to reserve 3 minutes if I could in rebuttal.
All right.
Judge, our position in this case with regard to issue 1 is the same as what this court said in the Smolka case cited in our brief back in 1995. The strong suspicion of guilt is legally insufficient. A suspicion cannot be the basis of a criminal conviction. The motion of judgment of acquittal in this case should have been granted because the state failed to show by direct evidence that the defendant was driving the car, and the circumstantial evidence failed to exclude every reasonable hypothesis of innocence. The evidence in this case came from various witnesses to a situation that occurred out on State Road 19 at its intersection with State Road 40 in Marion County.
What was the reasonable hypothesis of innocence here? What was his theory?
The defendant's theory, Judge, was he was not driving the vehicle at the time of the crash. 2 statements were introduced that the defendant made that particular evening into the trial, where he was questioned at length on 2 separate occasions regarding this particular situation, and in every occasion when he was confronted with whether he was driving the vehicle or not, he clearly indicated that he was not driving the vehicle.
And the other people in the car also indicated they weren't driving, right?
The other 2 people testified, Alexis Tobias and John Moore, that they, by inference, weren't driving the vehicle. They said they were behind in the back seat, passed out. Those statements clearly are untrue, given the other statements that they made to law enforcement that particular evening. Mr. Moore indicated at various points in his conversation with law enforcement that while in court, he said, "We passed out and I don't remember anything," that they hit something back around Astor, and at one point were fooling around in the back. Ms. Moore indicated at one point that they were talking, clearly inconsistent with what occurred. Also inconsistent with observations made by completely independent witnesses who have no access to ground with anyone.
Well, Mr. Moore testified that he never left the back seat, and he told the police that McMillen was the sole driver of the car from the time they left Volusia County, and that the car had hit something near Astor.
Well,
so what do you derive from that testimony?
Well, that is inconsistent with observations made of the vehicle, the persons in the vehicle, immediately before the last person, Miss Brady, as well as Miss Cundy, immediately before the crash occurred. Now, there were some observations made of a person getting out of the vehicle with one door open, Mr. Jett and Mr. Cowell, as they passed the vehicle as it sat. Miss Brady.
How do we know that the jury disbelieved them and believed Mr. Moore in his testimony and the logical conclusions that you derive from that testimony?
Well, it's circumstantial in and of itself, and it has to rise to the point to where it excludes every reasonable hypothesis of innocence, and our position is it doesn't, given the quality of the testimony of Miss Brady and Miss Cundy regarding what they observed at the time.
Why is it circumstantial? Number one is I understand that there's no dispute that this was the car that was involved in the accident. Would you agree with that?
That's correct.
All right. And the backseat passengers said the defendant was driving?
The backseat passengers said that the defendant was driving, along with they never left the back seat.
Why is that a circumstantial case as opposed to simply different witnesses testifying different ways and for the jury to sort out the fact?
Well, it's circumstantial in that it's a circumstance for the jury to consider, as well as the other evidence of other persons who contradict that and indicate that there was 2 people in the front seat and not one.
I'm sorry, I didn't understand. Why is that a circumstantial case?
Well, it's a circumstantial case, Judge, simply because the evidence indicates that while I think the evidence, if you read it with regard to Moore and them, they were also drinking and intoxicated and indicate they never left the back seat, that can't be true given what occurred with regard to the other testimony.
What if you had 6 eyewitnesses to the accident? 3 of them said defendant A was driving, 3 of them said defendant B was driving. Is that a circumstantial case because somebody must not be telling the truth?
Well, no, Your Honor, it's not, but that's the point in this case is nobody identified the driver of the vehicle in the courtroom. Tobias and Moore came in, and it's our position that while, if you want to consider direct or circumstantial, it still is such that it can't be believed in the context of what their stories that they were telling versus independent witnesses. If you match the two up, it's not enough to support the guilty verdict in the case.
But there were only 3 people here in that car. That's the vehicle that was involved in the accident.
That's correct.
We're settled on that. There were only 3 people that could have been driving the car. It wasn't driving itself. Somebody was driving it.
That's correct.
And the 2 people, the man and the woman who had been in the back seat, say they didn't leave the back seat before the accident occurred.
Well, and that's true, but given the quality of the testimony of the other witnesses and their testimony and contradicting testimony, that can't be believed.
But isn't that why we have juries to sort out that discrepancy in testimony among witnesses?
Well, it is, but it's subject to some review, and that's kind of the position that we're at right now. You know, the witnesses in the case, the 2 witnesses who saw that vehicle just before it left on its final path before its collision and causing the death in the case, indicated there was clearly 2 people in the front seat.
But doesn't the jury have a right to disbelieve that testimony?
Well, they do, but in this case, it's hard to understand how that could happen.
Well, whether it's hard to understand or not, that's what the jury has a right to do, correct?
Correct.
The passenger said, I'm in the back seat. 2, quote, independent witnesses say, I saw somebody in the front seat. That's a jury question, isn't it?
Well, it is subject, again, to a review in the case, whether it rises to the level.
What about the testimony that Jewett, Cole, Brady, and Cundy described the individual getting out of the car near the driver's door as a man with hair, and the people in the back were a woman that had long hair and Moore who had a shaved head? Well, I don't think that testimony doesn't.
Well, no, that I don't believe was the testimony. Miss Brady only saw and described 2 people in the front seat. She described a man, but she was describing someone 5'10" to 6 foot with not a man's typical haircut, was longer below his ears and pulled
well, it was
back.
a man. They described a man getting out of the driver's portion of the car as a man with hair. And the 2 people in the back, there were only 3 people in the car. One was a woman with hair, and Moore had a shaved head.
Well, but she's describing another person in the front seat. That's kind of my point. She has clearly said that there are 2 people in the front seat. What she did was she described the person, the same physical description. If you look at it in terms of height, weight, and we've got Miss Tobias admitted in her cross-examination she was in the range of 5'10", 160 pounds, curly, kinky hair, pull back, ponytail. All, if you match the 2 up together, literally the same or close to.
I have one more question. Has this issue even been preserved to present to us for review?
Well, the issue that, Judge, the rule clearly requires that the trial judge be placed on notice of the issue before it. And in this case, it clearly was. There was no other issues involved in the case regarding.
Did you state in your motion to the trial court that your motion for judgment of acquittal that, Judge, there's not sufficient evidence here that we can see that places this fellow behind the wheel, that he was even the driver? Well,
in the context, we've cited the Jagers and the RS case for the proposition that when it's clear from the context of the record, the issue that you are arguing, the boilerplate type of language which was used in this case, is fine. the purpose of the rule is to put the judge on notice of what you're doing, and I
How's the
think...
judge supposed to be put on notice when you present a boilerplate motion for judgment of acquittal and you don't present the issue to the judge as to who was the driver and that there was insufficient evidence to make that proof?
Well, if there were other issues presented, then I might agree with you. But there wasn't any other legal issues present at this time. The only issue at this case, from the time the case was argued in the opening statement to the cross-examination of the witness, was who was driving the vehicle at the time.
Did you stipulate that this vehicle was the one involved in the accident, or did you require the state to prove that?
We didn't stipulate it, but they clearly proved it.
Well, how do we know that? How do we know that since they had to put evidence on that, how do we know that your motion for directed verdict may have been on the basis that you weren't satisfied with their proof that this was the car that was involved in the accident?
Well, the issues in the DUI manslaughter was the person was driving a vehicle and caused the death of the persons involved and was either impaired or over the limit. So I don't know that...
Well, the state had to prove that his vehicle was involved in the accident, correct?
Well, had to prove a vehicle was involved.
All right. And you didn't stipulate that his vehicle was involved in the accident,
Well, there was
correct?
never an issue of whether a vehicle caused the damage.
The question is not a vehicle, it was this particular vehicle that they then tried to establish the defendant was driving, correct?
Well,
If there were a defect in their proof about whether this was his car, that could have been a basis for a motion for a directed verdict, right?
well, it could, but it wasn't. I mean,
Well, how do we know
wasn't-
that? Because your motion for directed verdict just says they didn't prove their case. How does the trial court know you're not arguing they didn't prove their case because you don't think they got the right car?
Well,
Or perhaps didn't name the right county in which the accident occurred.
Well,
For
those are
jurisdictional
just,
purposes.
if you've read the record, those were not just not issues. I mean, the only issue in the case, from the opening statement to picking the jury to everything, was just who was driving the vehicle at the
Well,
time.
then the state didn't have to put on evidence of what the car was.
Well, they chose to do that. I mean, it was not...
Must have been an issue then, right? Because you could have stipulated it away and kept all that evidence from having to be put in, right?
They could, but it was not objected to. They put it on, so it was clearly...
Your basic argument is that this is fundamental error, and therefore you have the right to present the issue to us for review.
Well, no, as far as I'm concerned, under the Jaggers and the RS case, and if you read...
Well, are you claiming it's fundamental error?
Well, it would be if you find that it wasn't preserved, but it's my position that it was...
Okay, well, if we say it wasn't preserved, your fallback argument is that, well, it's fundamental error. And I guess my question to you is, if in judging a motion for judgment of acquittal, the trial judge has to take the evidence in the light most favorable to the state, and we've got Moore's testimony and the testimony of these witnesses about the person getting out of the driver's side with head hair, I guess my question to you is, given that standard that the trial court has to apply to determine whether your motion should be granted or not, how is it fundamental error?
Well, it would be fundamental error because it rises to the constitutional nature of the issue in question, and that is
maybe if the state had not put on any evidence that would allow these reasonable inferences to be drawn in favor of the state, I could say that maybe you might have some sort of an argument that we could consider, but when they put on that sort of evidence and the trial judge has that standard to view the motion by and to determine whether it should be granted or denied, I have a hard time finding that, given the evidence presented in this case and the inferences that have to be drawn from it, that this constitutes fundamental error. So if we say then that do you concede that it's not fundamental error based on the standard that the trial judge has to review the motion? I would concede that, but it's my position, and likewise, if the court looks at its own opinion in Raines versus State at 671-815, where Judge Griffin dissenting argued a shotgun motion isn't enough, that was clearly rejected by the majority in that particular case, where the only issue presented was the one in question. Thank you all very much. I'll reserve the remainder of my time.
May it please the court, my name is Chris Davenport and I represent the state of Florida. I think this JOA motion is a bare bones motion. It didn't preserve this issue, and even if it had, there's clearly sufficient evidence here. We have the passengers in the car, we have a lot of witnesses who saw him right before the accident.
Is his representation to us essentially accurate? That the only issue really that was contested in this case, the only issue was who was the driver or whether the defendant was the driver, and causation and intoxication and that sort of thing were really not issues that were confronted in the case.
Well, I think there was so much overwhelming evidence on those other issues that they didn't argue it to the jury.
Did the state present evidence as to the level of blood alcohol and that there was causation and?
Yep. And that it was his car. All of those things the state had to prove. Nobody stipulated to all of that. It's not like they said somebody was drunk, somebody hit him, but it wasn't this guy, and that was all they talked about. I mean, everything was contested.
Is this a circumstantial evidence case?
I think it's a direct evidence case because of the testimony of John Moore, who was in the car and said the defendant was driving. I think that's direct evidence.
Did he say he was driving at the time the accident occurred?
He said he was driving. He said the defendant drove the entire time. The woman in the car said the defendant drove the entire time. At trial, they both said they were passed out. John Moore said to the police that he knew there was an accident around Astor. But
and did he say something about having woken up because the car hit something or something like
right.
that?
That's what he said to the police. At trial, they both testified they only woke up when he was pulled over. So I think that makes it a direct evidence case, yeah. We would ask you to affirm. Thank you.
Yeah.
Any rebuttal? No, sir. Thank you.